Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the McDermott, Will, and Emery law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, a publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed patent enforcement by non-practicing entities, also known as NPEs or patent trolls. In this podcast, I'll discuss some aspects of non-U.S. patents. I and my co-author, Joanna Dombrowski of General Electric Company, covered this topic in the August 2013 column in Computer Magazine. The first question to consider is, why would you want to file for a patent application outside of the United States? And the answer to that depends on a number of factors. First, where do you want to protect your invention? U.S. patents only protect inventions within the borders of the United States. So if you want to protect your invention in other countries, you'll most likely need to have a patent issued by that country or countries. Secondly, you might want to consider filing in other countries where you have significant competition. If your competitors have headquarters or large operations in certain other countries, you might want to get patent protection in those countries as well to protect your invention there. Also consider where you have significant markets that you want to protect. Sometimes large markets are outside the United States, parts of Europe or in Asia, for example, and your U.S. patent will not protect your invention in those markets, so you could be subject to an infringement in the other markets and have little recourse unless you have a foreign, non-U.S. patent issued by the jurisdiction in the jurisdiction where you want to protect your invention. Once you decide that you do in fact want to file for foreign patents, that is, file an application in a foreign country, the question comes up is, how do you do that? Well, there are several ways to file a patent application outside of the U.S. Similarly, you can file an application directly with the country that you're interested in, and if you want to get patent protection in several countries, that would mean filing an individual application in each specific country of interest. But there are, however, alternatives that allow you to file applications effectively in more than one country at one time. So, for example, there are certain regional associations of countries that allow you to file one common application that can be used in all of the countries within that particular region. For example, the European Patent Office has a number of European countries that will accept a common application. You could file your application directly with the European Patent Office and thereby have the effect of filing an application in multiple European countries at once. However, the Patent Cooperation Treaty is the most common method for filing an application outside of the U.S. when you have multiple countries in which you would like to get patent protection. The Patent Cooperation Treaty, known as the PCT, is an association of about 150 countries worldwide that have agreed to abide by certain rules and conditions that allow for a common application to be filed that each country will accept as an individual application for a patent in their respective countries. The procedure is relatively straightforward. It's usually done at the same time you're filing for your initial patent application. There are some deadlines you need to be aware of, and those are covered in our column. However, the procedure is essentially to take the same application that you're initially filing, say in the U.S., for example, add some additional cover sheets that are specific to the Patent Cooperation Treaty, or PCT, and then file that package in the so-called receiving office. Now, the receiving office is a specific office that's designated to receive these international applications, and there are several around the world. The U.S. Patent and Trademark Office is one such office. There's also the main office in Geneva, Switzerland. However, when you file your application in the receiving office, at least one applicant, either a person or a corporation, must be a citizen or a resident of the country in which you are filing the application. That is, if you're filing in the U.S. receiving office, you have to ensure that at least one applicant is a citizen of the United States. You can always file in Geneva irrespective of the citizenship or nationality or residence of any of the applicants. Now, what is it that you file? As I mentioned, you basically file the same version of your initially filed application. Using the U.S. application as an example, you would file the specification, the claims, and the drawings, all as you have done in the United States, plus a couple of specific cover sheets that identify it as an international filing and help you compute the fees associated with filing an international application. What's important to keep in mind is an international patent application filed under the PCT does not turn into an international patent. There is no such thing as an international patent or a patent that would give you coverage throughout the world. Instead, the Patent Cooperation Treaty provides a vehicle to use a single application that multiple countries around the world will accept as their own patent application. The countries that you're ultimately interested in pursuing patent protection in will then treat that application as a specific application for a patent in their country. Now, the process for getting a patent issued in a particular country using the PCT is known as nationalization. That is, within a certain time frame, an applicant who files a PCT application must ultimately decide which country or countries he or she wants to file the application in and pursue a full patent. When you file your application, you're entitled to select all of the countries that are part of the PCT organization. That's about 150. However, it's rare that you would ever file in all of those countries, not only because of the expense in doing so, but because many of them will not be of any interest to you. They won't have any particular market that you want to exploit or any particular competitors located within their borders. So instead, you'll pick a handful of countries at some point down the road before the deadline and pursue the patent issuance in those specific countries. Now, you must make your selections, you must make your nationalization selections within 30 months of the filing in most cases. So that gives you about 2.5 years of time while the application, the PCT application, is pending, and you can use that time to further analyze your potential countries of interest, analyze markets, and take a view of your expenses and budgets for international filings. Once you file your PCT application, you are accorded an official international filing date. This is something like a filing date that you get when you file a U.S. application. It's basically a stake in the ground that says, this is the day on which I filed my international application. Shortly thereafter, you will receive what's called an International Search Report, or an ISR. This is a document that gives an initial view on the patentability of your invention and your application's compliance with certain formalities. That is, the types of pages and margins and other ministerial requirements about the application. Now, the International Search Report is conducted and issued by the International Searching Authority. There are about 16 of them around the world. The U.S. Patent Office is one of them. And when you file your PCT application, you can select which international search agency you would like to have perform the international search and issue the report. Once the report is issued, it will ultimately be sent to all countries where that application is ultimately nationalized. And in broad terms, there are two types of international search report results. They're either good or they're bad. If they're good, that basically means that your invention, as you claimed it, is generally patentable. If they're bad, that international search report will provide certain references that the examiner believes either render your invention not novel or, in using U.S. terminology, obvious. Now, what you do in response to getting an ISR generally depends on the type of ISR you get. If you get a good ISR that's patentable, suggesting that your invention is patentable, you really don't need to do anything in response to the ISR. However, if you have a bad ISR, indicating that the invention is not patentable, then it's likely you're going to want to file a demand for what's called an International Preliminary Examination Report. This is, in effect, a reissuance of the ISR. However, it gives you, the applicant, the opportunity to respond and make amendments to the claims at this stage. Now, why would you want to make amendments at an international application? Because, as I said earlier, there's no such thing as an international patent. Well, part of the rationale is because you can make amendments now at this stage before the application goes into the individual countries as part of nationalization. So instead of having to make the same amendments multiple times in multiple countries, one amendment at every place, for example, where you have nationalized the application, you might be able to make an amendment now before nationalization. That will allow you to get the claims into a more patentable state before they ultimately go in for further examination in individual countries' patent offices. That ideally cuts down the overall prosecution time and will shorten the delay in getting an issued patent. Part of the reason for that is because the International Preliminary Examination Report, also known as an IPER, will get sent to every patent office in the countries that you choose to nationalize in, and your amendment in response to that will also be sent. So the ultimate examiners in each country will see the arguments raised by the search authority and your response to those arguments, and that may allow each examiner in each country to allow your patent application based on your responses. However, every country is a little bit different in terms of how they examine patents, so there might still be some work to be done, but the obvious objective is to try and do it uniformly across the board before you need to do it individually in each office in the countries in which you've nationalized. Ultimately, when your patent application is nationalized, you or your patent attorney will be working with other patent attorneys in each of the jurisdictions in which you've nationalized it, in each country in which you've nationalized. The reason for that is each patent attorney is usually required to have somebody who is resident in the countries in which you nationalize, who's most familiar with the very specific country forms and can more easily interact with the patent office given their location. But it's important to know that your patent attorney must maintain consistency in the arguments raised across all the different patent offices as he works with his counterparts in other countries to address rejections and to enter amendments. You just want to make sure that the arguments being raised in one country do not differ or contradict arguments being raised in another country. The reason for that is such discrepancies can give significant fodder if the patents are ever involved in a patent infringement lawsuit or other litigation. During litigation, it's very common to see arguments being made that are relied upon in terms of how a patent is going to be construed as part of an infringement analysis. That means if arguments have been made, say, in the U.S. Patent Office during the prosecution of a patent that describe what the patent covers, and other arguments are made that differ from those first arguments, and they're made in other patent offices, that can have an influence in how ultimately patent claims can get interpreted. A particular area of danger is if examiners in other countries do seem to find prior art that is relevant to your patent that the U.S. examiner might not see. It's extremely important to make sure your U.S. examiner knows what is going on in the patent prosecutions in other countries, particularly when prior art is being cited by examiners in these other countries. The failure to notify a U.S. examiner of relevant prior art that you or your patent attorney knows of by virtue of prosecution in other countries could raise serious questions about the enforceability of a U.S. patent. In particular, it might lead to a conclusion that certain prior art that was particularly relevant was being hidden from the U.S. examiner to allow a patent to issue that maybe should not have issued in view of that prior art. Because of that, it is best to be fully open with your U.S. patent examiner and make sure he or she is aware of what prior art's being cited by other patent offices. Of course, that applies so long as your U.S. application is still in the prosecution phase. If your U.S. patent is issued, there's really no point in providing any art to the patent office at that point, unless, of course, you might want to seek to have the patent re-examined in view of prior art that concerns you and that could cause the validity of the patent to be questioned. To sum up, having patents in multiple jurisdictions or multiple countries makes sense in view of the international aspect of most businesses. Try to obtain patents in every country where you have significant business that you want to protect. However, keep in mind that some countries make it very difficult to enforce patents, meaning that if you have trouble with an infringer in a foreign country, you might have trouble stopping them because the court systems there aren't terribly friendly to patents or do not have a history of enforcing their patents. Applying for patents in multiple countries is very expensive, so choose wisely when considering the significance of the markets and the likelihood of successful enforcement. I hope that you found this podcast helpful in understanding some issues about non-U.S. patent applications. Stay tuned for the next installment in Computer Magazine. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@mwe.com. Thank you.